Hello and welcome to the Entrant. The topic for today's discussion is mens rea under IPC. So firstly, let us introduce the topic very briefly. Mens rea and actus rea are two components for constituting a crime. Mens rea means guilty mind and actus rea means guilty act. These two things are necessary for constituting a crime. A person cannot claim until these two elements are present in the crime. The Latin phrase actus reus non facit reum nisi mens rea means an act does not make a person guilty unless mind is also guilty. Actus reus amounts to physical element of a crime. It can the form of an act, an omission, or a state of affairs. Mens rea amounts to mental element of a crime. It's what goes on inside the defendant's minds. It's direct intention, indirect intention, or recklessness of a person. For example, the mens rea of a battery is intention or recklessness. Further, we will discuss the origin and doctrine of mens rea. The maxim actus reus non facit reum nisi mens rea is essence of criminal law. Some courts says that this principle is a sacred principle of criminal jurisprudence. Most of the courts say it's impossible to do crime without mens rea. The criminal should intend to do the crime. The roots of the concept mens rea was from the Anglo-Americans' criminal law. Mens rea refers to criminal intent, the literal meaning of Latin guilty mind. The plural of mens rea is mentis rei. A mens rea means mindset of criminal while performing crime. It's necessary to prove mens rea to punish the accused person. The prosecution typically must prove, keeping aside the reasonable doubt, that the defendant committed the offense with a culpable mindset. Justice Holmes famously illustrated the concept of intent when he said, "Even a dog knows the difference between being subsumed over and being kicked." Now, moving on the principle of mens rea, that is, factus non facit reum nisi mens rea. It is the well-known Latin maxim enunciates the relation between mens rea and a crime in general. Actus rea means wrongful act, mens rea means wrongful intention. The maxim means that an act does not itself make one guilty unless the mind is also guilty. The mere commission of a criminal act or also violation of law does not amount to crime. It generally requires some additional elements to prove the act as crime. Mens rea is a technical term. It is one of the essential ingredients of criminal liability. A criminal offense is said to have committed only when an act done voluntarily. Hence, an act becomes criminal only when it is done with a guilty mind. In the fifth slide, we will move forward with the presumption which was taken under IPC for mens rea. The presumption here is that a criminal act requires mens rea. All offenses that exist independently of any statute also requires criminal mindset. Where a statute creates an offense, it requires elements of mens rea to constitute that as an offense or crime in eyes of law. Hence, the plain words of a statute read subject to a presumption of arguable weight, which may rebut that the general rule of law that no crime can be committed unless there is mens rea has been ousted by the particular enactment. So in the case of Brent versus Wood, Lord Goddard, Chief Justice, held that It is of the utmost importance for also the protection of the liberty of the subject that a court should always bear in mind that unless a statute either clearly or by necessary implication rules out mens rea as a constituent part of a crime, the court should not find a man guilty of an offense against the criminal law unless he has a guilty mind. I hope this slide has helped you in clearing the concept. Now, in the sixth slide, we shall be summarizing the essentials of mens rea. First, the mens rea is constructed from a person's thought process, their motive and intention. Motive and intention are two separate ideas. Motive is the reason behind the act, whereas intention is a person's state of mind and willingness to break the law. Presence of both motive and intention facilitates the prosecution of a crime, but motive is not a necessary element for conviction. Intention, whereas on the other hand, is more important than motive. It is a subjective fact which is required by the criminal law by the prosecution. For example, a person takes another person's bike with them in good faith, but it was taken without consent. This act will be considered as theft. I hope the difference between intention and motive is clear. Now, in the seventh slide, I shall be answering a very important question, which is how can mens rea impact a defense? So, in IPC, under the chapter of general defenses, the crimes that are mentioned does not contain mens rea and hence can be used by the defense to prove that there was no guilty mind involved in their actions. Basically, this chapter contains conditions prohibited actions that has taken place, but the wrongdoer does not have mens rea. The conditions in which a person is not in a state to make a decision what is right and what is not is when that a person is of unsound mind, involuntary intoxication, minor, working in good faith, bound by their occupation, mistaken by facts, etc. So that's all for this topic. Now we shall be summarizing it, and the conclusion would be that motive is an indirect way to prove that something was done intentionally or knowingly. For example, a defendant in an assault case may claim that he punched the victim by accident and thus didn't have the necessary intent for an assault. If the prosecution can demonstrate that the defendant and victim had been arguing shortly before the alleged assault, that motive can serve as circumstantial evidence and a defendant that a defendant really did intend to punch the victim. Alternatively, defendants can use the prosecution's lack of evidence of a motive as a reasonable doubt to avoid criminal liability. Another consideration in dispensing with a mens rea requirement is ignorance or mistake. It is commonly said that ignorance of fact excuses from liability, whereas ignorance of law does not, although this simple formula holds true in wide areas of the criminal law. There are important exceptions, especially in the area of absolute liability offenses. In such cases, a mistake of law is increasingly being allowed as a defense, especially under statutes that impose harsh penalties. Finally, all criminal systems make provisions for certain types of diminished responsibility such as intoxication, infancy or insanity. All countries specify a particular age at which youths may be held responsible for the consequences of their acts. So intoxication is commonly held not to be a defense to a criminal except insofar as it negates the existence of a particular mental state. For instance, in Indian law, person who commits murder while intoxicated are convicted of culpable homicide amounting to murder than murder if it is found that they were incapable of entertaining the malice aforethought requisite to a finding of murder. So that's all for today's discussion. Thank you. Hello and welcome.